On October 16, 1968, biology teacher Susan Epperson entered the Supreme Court of the United States to take a stand for the separation of church and state by challenging Arkansas's Act No. 1, a ban on teaching evolution. 1 month later, the Supreme Court ruled unanimously that it was unconstitutional to forbid the teaching of evolution in public schools. The Supreme Court found that the Arkansas law advanced a particular religion. This case provided legal backing for important future court decisions about evolution, such as banning the teaching of creationism. Susan Epperson took a stand to shape the way that we teach evolution today. Back in 1859, Charles Darwin published his theory of evolution in The Origin of Species after studying organisms on the Galapagos Islands. In 1912, George Atkinson's widely used Botany for High School was published, which stated that evolution, quote, has been accepted. Most high school textbooks for biology taught evolution. After World War I, many influential public figures such as Secretary of State William Jennings Bryan advocated a return to traditional thought and values. He said, "The same science that manufactured poisonous gases to suffocate soldiers is preaching that man has a brute ancestry and eliminating the miraculous and the supernatural from the Bible." Proponents of teaching creationism began advocating for banning the teaching of evolution in public schools across the United States, and in 1923, Oklahoma's governor signed the first law banning evolution. Anti-evolution laws were signed in over 20 states. This history culminated in the Scopes Monkey trial, taking place in Dayton, Tennessee in June 1925. William Jennings Bryan prosecuted with acclaimed lawyer Clarence Darrow defending John Scopes, a substitute teacher who assigned a section on evolution in a state-approved textbook. He was prosecuted for violating the Butler Law, quote, an act prohibiting the teaching of evolution theory in all the universities, normals, and all other public schools of Tennessee, which are supported in whole or in part by public school funds of the state. He was found guilty, and for the next 30 years, no textbook dared print another word about evolution. Susan Epperson was a 10th grade biology teacher at Little Rock High School. In 1965, the Little Rock School Board approved a textbook and curriculum containing evolution for the first time in the 40 years after the Scopes case. Had she not followed district curriculum by teaching evolution, she could have been dismissed. However, a referendum of the citizens of Arkansas banned the teaching of evolution in a 1928 bill, Act No. 1, and she could have been fined and dismissed had she taught it. In the 1960s, a new movement was rising in Arkansas to take this law off the books. They wanted an Arkansan to challenge the law in court without outside influences like the ACLU or NEA. Susan Epperson was the perfect plaintiff, a religious Catholic in this legal predicament with a desire to teach evolution. When she challenged the law in court, many parents, teachers, students, and clergy took a stand to support her case and education about evolution. One parent and secretary of the Arkansas Education Association, H. Blanchard, even joined her in the lawsuit. The Little Rock Ministerial Association supported her, saying, "To use the Bible to support an irrational and an archaic concept of static and non-developing creation is not only to misunderstand the meaning of the book of Genesis, but to do God and religion a disservice by making both enemies of scientific advancement and academic freedom." She also had the support of roughly 75% of biology teachers across the country, according to a meta-analysis by Paul Wendell in 2006. Susan Epperson filed in the Chancery Court in Pulaski County, Arkansas, which decided in her favor. It found that the Arkansas law violated the First Amendment's Establishment Clause, which protects freedom of speech, as well as violating the 14th Amendment's Due Process Clause because the law was too vague. The court said the law, quote, tends to hinder the quest for knowledge, restrict the freedom to learn, and restrain the freedom to teach. The state appealed to the Supreme Court of Arkansas, which reversed the lower court's decision. Finally, Eugene R. Warren, the attorney for Ms. Epperson, filed a petition for writ of certiorari, or application, for the United States Supreme Court to hear the case, which was granted. Warren argued for the plaintiff Susan Epperson. He left the First Amendment arguments to the amicus briefs, extra arguments the justices read. He focused on how the law violated the Due Process Clause of the 14th Amendment by being vague and overreaching. He argued teachers were confused as to whether or not they could discuss the existence of the theory of evolution or evidence for and against it. He also brought up the implications if the state's interpretation of the law is accepted.
The language of the Act also forbids the teacher to use a textbook in which this theory is, as the Act says, a textbook which teaches the theory or doctrine. All of the source reference books, general reference book, in every school's library contains an explanation of this theory. Well, now, if the Act has that sort of meaning, then that means that every school has got to rid its library of all of these books, and that's just plain ridiculous. That's book burning at its worst.
The lawyer for the state of Arkansas, Don Langston, countered the accusation that the law was unclear and violated the Due Process Clause. He referenced the Scopes v. Tennessee case as precedent for Act No. 1 being clear. He also defended the constitutionality of the law by clarifying the state's interpretation of the law.
To make the student aware of the theory, not to teach whether it was true or untrue, but just to teach that there was such a theory would be the grounds for the prosecution under the statute. That the state has a right to set the curriculum in its schools, and that's our main point, Your Honor.
When the justices came down with a decision, the vote was unanimous in favor of Susan Epperson. The main opinion, supported by 6 members of the court, was written by Justice Abe Fortas. The reasoning for their decision was primarily based on the First Amendment arguments that, quote, Arkansas's law cannot be defended as an act of religious neutrality. Arkansas did not seek to excise from the curricula of its schools and universities all discussion of the origin of man. The law's effort was confined to an attempt to blot out a particular theory because of its supposed conflict with the biblical account literally read. Plainly, the law is contrary to the mandate of the First and in violation of the 14th Amendments to the Constitution. Justice Harlan concurred on similar reasoning. Justices Black and Stewart concurred with a majority opinion, but their reasoning was that the statute was so vague it couldn't be ruled unconstitutional under anything except the Due Process Clause of the 14th Amendment. The immediate implication of this decision was that it was now legal across the United States to teach the theory of evolution in public schools. The justices' interpretation of the law was also used in related cases, most importantly Edwards v. Aguillard, a challenge before the U.S. Supreme Court to a Louisiana law that mandated equal time be given to creationism and evolution in public schools. Don Aguillard challenged these equal time laws, also enacted in other states, on the basis that they involved state endorsement of teaching creationism, a religious belief. The decision was a 7-2 vote in which the Supreme Court decided it was unconstitutional to teach creationism. Lawyer Nicole Moen shows the connection between Epperson v. Arkansas and Edwards v. Aguillard.
Well, so I think Epperson clearly sets the stage for the Edwards case. And I think, they look back at Epperson and, is it moving the law farther? I think, yes, it is. But Epperson provides that crucial step to allow them to get there.
Finally, in 2005, the judge in the case Kitzmiller v. Dover Area School District found that teaching intelligent design was also an endorsement of religion by the government, ending legal justification for teaching God-driven creation. The judge based his decision off of precedent from Epperson v. Arkansas.
These types of laws, even when they're in one, this was, of course, an Arkansas law, and it only had effect in Arkansas yet, but when these laws are allowed to stay on the books, they really do have an impact across the nation because they embolden other states to pass similar laws.
Though over 5,000 schools that receive public funds still teach creationism, this is much less than the many tens of thousands that used to. Epperson v. Arkansas turned the tide of the evolution-creationism debate in favor of the proponents of evolution, which is how policy and education remains today. Many stakeholders in education felt that a ban on evolution hampered the government's ability to be secular. This large group of people, with a diverse range of thought, took a stand for what they wanted the separation of church and state to look like in our education system. This case helped U.S. schools and science classrooms evolve into how they are today.